So, I guess talking about enforcements, I think the enforcement that I was most, I don't know, I guess shocked about or just like annoyed by, was whenever I had a client. This was like freaking 10, 12 years ago. It's when Judge Owens was on the bench. And basically, they had filed an enforcement. It was an enforcement. It was a final, I think, divorce hearing or final modification hearing. And the enforcement was for a violation of an injunction for smoking tobacco cigarettes in the presence of the kiddo, because the kiddo was asthmatic or had some health issues. And so, of course, before the hearing, I talked to my client, and she's like, I don't smoke cigarettes, I don't smoke tobacco, it's not an issue. And I'm like, okay, well, great.
Well, that's one of those that's really hard to prove, right?
Well, yes, but in this particular case, I think the kid was like 5 or 6 years old, and he was at mom's house, and he was running through the kitchen, and she's sitting at the dining table. And as he runs past her, he gets burned. Like, I guess like right in his chest, he gets burned with a little round circle, that cigarette shape.
That might be proof.
That was pretty freaking good evidence on the other side, I thought. And so she swore up and down.
Wait, it was against your client?
It was against our client.
Yeah, fun.
Yeah.
Okay.
And so she's up there and she's testifying, and they're showing her pictures, and she's like, yes, that happened at my house. I guess somehow the dad had found out, or she had admitted like in a text message that yes, it was her who had done it. And so they're questioning, and then finally the other attorney is like, so you were in fact smoking a tobacco cigarette, right? Which we all know you're not supposed to ask that last definitive question. But he did, and so she says it wasn't tobacco, because she was at this point pissed, and so she was going to make it a point to say it wasn't tobacco. And so the judge looks at her, and judge is like, well, what was it, ma'am? And then she looks at me, and I look at her, and I just put my head down, and he was like, you're going to take your seat. Take your seat. And so they didn't win on the enforcement, so she did go to jail. So that was.
Wait, what was it? Are you gonna tell us what it was, or would you have to guess?
What do you think it was, Floyd?
What
else is typically rolled like a cigarette that you smoke that could cause a burn?
I have no. If you're referring to drugs, I have no knowledge of drugs, so I don't know how that would be done.
So, it was marijuana, so we won the enforcement. She didn't go to jail, right, which was awesome. But judge was not very pleased with her for doing that, and so we ended up I think getting supervised visitation for an extended period of time. And so
we had a problem with her smoking marijuana around the child.
Yeah, a little bit. So that's one of the things that when you're listening or talking about enforcements, that you have to understand what the verbiage is. And so pretty funny.
Yeah, so welcome to the consultation, guys. Clearly, we're going to be talking about enforcements today. My name is Josh Floyd. This is Christina Jimenez. We're both attorneys here at the Jimenez Law Firm, practice family law and criminal defense here in Texas. And we thought enforcements would be a good thing to discuss. So, you want to do that today?
I would like to do
Let's
that
do it.
today. So, the first thing that we're going to talk about is understanding your order. And so clearly
it's a big one.
In the story that I just told, she understood her order, right? So she was not going to smoke nicotine.
Wait, did she understand, or was that something you put in? Like, look, if you're smoking tobacco, it's a violation. Marijuana, not so much.
So I wasn't her attorney in the previous order. I don't remember who it was. So it must have been a modification, because obviously there was an order in place. But it was very clear that it was tobacco, right? And so I don't know if she understood her order or if she just chose to smoke weed. I don't know. But the first thing is understanding your order. So here at our firm, what we do whenever we're getting either a temporary order in place or we're getting a final order in place is we actually sit down and talk to clients about it, review the order with them. And that's not something that we always did, like when we first started. Yeah, we would just kind of go through it. We would make sure it was correct. We'd sign it. We'd email it to the client and say, here you go. Now you have your information. But I don't remember. I'm sure something happened where, maybe somebody didn't know what it said.
Didn't understand it that way, or
And then
we learned a lesson.
We learned a valuable lesson. And at that point, we said, okay, from this point forward, we're going to tell or sit down and review this with all of our clients because it's important that they understand it, right? Now, granted, some clients are maybe not fully paying attention, or maybe they're just not,
or don't care.
Brightest Crayola boxes. I don't know, but we do at least make an effort to sit down and go over it with them.
Yeah. So I get asked that a lot, right? So there's a difference in what's in the order that you should do, right, versus being ordered to do, right? And the one that comes up the most time is possession, right? So if I'm ordered, or if I'm supposed to deliver the child, or I'm ordered to deliver the child to this location at this time, right? The client will call that has the child and be like, he didn't pick him up, he's in violation. Like, no, he's not ordered to pick the child up, right? That's not a violation. You're ordered to deliver the child. So if you didn't deliver the child, that's a violation. But his failure to pick it up, not a violation, right? And so there's a lot of terms in the order that they need to understand. Like, this is an order from the court. I could be in trouble for this. This, not so much, right?
Possession and access is always something that's super confusing to people, especially when we're looking at a standard possession order. We want to make sure that that you're looking at it, you're understanding it, because if you don't understand your order and enforcement, then you can be held in contempt of court, right? And so possession and access is super confusing. There's weird little things like having to notify the other party if if you're moving, or you change your employment, or you change your phone number, things like that people don't think about. It's in your order. I can guarantee you that it is. And most of these orders are 30 pages long, and you're going to be held accountable for what's in there, whether you take the time to read it or not.
So in your opinion, and I know this is non-scientific, do a lot of other lawyers do this as a practice, or is this unique to Jimenez Law Firm?
So I don't know that they go through the orders like we do, right? So enforcements are common, right? Most of the time they're reserved for possession, access, and child support, right? But when someone files an enforcement, or there's an enforcement pending against another party, that can be used as leverage, right? Because that other party, we'll get to the consequences later, but it could be looking at jail time, right? And so if we go through, like, let's say we get a client that has some problems in their case, right? A way to leverage that is to go through the order with a fine-tooth comb and figure out a way the other party violated that order, right? With some language like the notification of employment changes or address changes, or some injunction that maybe they messed up on that nobody really paid attention to, right? And so we could take that, file an enforcement, and then use that as leverage to kind of offset the negatives of our client.
I'm going to object as to non-responsive at this point. I'm objecting as to non-responsive.
I'll overrule that.
You didn't answer the question. The question was, do most attorneys do that with their clients?
Counsel, I believe the question was answered in the very first sentence when I said yes, just not to the extent we do.
Oh, did you say yes?
We go through it with a fine-tooth comb.
Okay, I didn't hear the yes.
They typically reserve theirs for child support, possession, access.
Narrative
would have been a valid objection. That would have been sustained, but...
So, I don't know if you realize this, but you're on the same team. So what's your take on it? You can have a different take. What is yours?
Oftentimes, although we're the same firm, we have conflicting
Fair enough.
But I
ideas.
think that's what helps us to actually be a good team, because we're always
calling each other out. Yeah.
It's a conflict that helps us find like the actual correct answers. So I will say that a lot of times when we have new clients, and especially if an enforcement's been filed, I hear so often, my other lawyer never reviewed this with me. I had no idea what was in this order. Nobody ever talked to me about this. And now I'm potentially going to jail. And if I had known this, then I would have done it, right? So, which actually, I guess, leads us to the next thing, which is the consequences. Yeah?
Yep. And so clearly today, guys, we're talking about enforcements, right? We're going through the 3 points. We just went over kind of understanding your order, the importance of that. And so now we're going to move on to consequences of an enforcement, right? And so what happens?
Well, there's different consequences. So there's civil contempt, there's criminal contempt, there's suspended commitment, and then there's payment of attorney's fees. And so I guess the one that we normally file under is the criminal contempt. And so with criminal contempt, you can be confined in county jail for up to 180 days for violating an order. And so basically it's you didn't do what you were supposed to do, and so now you get to go to jail. And it's up to 180 days. It could be 2 days, it could be 30 days. I mean, it's up to the discretion of the court. Okay?
And so that language is in the bottom of each order, right? You violate the condition of this order, you could be held in contempt, fined up to $500 per violation, and sentenced to jail for 6 months. But the fine is something I don't see used a lot, right? I mean, attorney's fees, jail time, suspended commitment, that kind of stuff is pretty common, but I don't know that I've ever seen a fine assessed for a violation of a court order.
Where does the fine money go? Do you know? I don't know, because we never use it.
I don't know.
I would presume that it goes to the
County.
You think?
Don't all fines go to the county?
I would think so. Yeah, we never file with fines, but that is also another consequence, is a fine of $500. I forgot about that.
Per violation.
Per violation.
And it's 6 months per violation also.
Correct. So the 6 months per violation is, you rarely see that also. I mean, we normally run those
They don't stack them,
concurrently.
yeah.
Yeah, so a judge, I guess they can in theory stack them, but it's not very common. They're going to run you at just a straight 180 days for all violations. And so, with regard to the civil contempt, what is that?
So, civil contempt, criminal contempt, like what Christina was just explaining, is punitive in nature, right? Civil contempt is just to get you to comply with the order. And so, civil contempt would be like, if you're behind in child support, they lock you up until you are current, right? So, you're punished, could be by incarceration, until such time as you comply with the order. It could be if you didn't sign a deed, it could child support, whatever the case may be, to get you to comply with the order. And then once you've complied, your punishment is over. You're out of jail or whatever the case may be. And so it's not punitive in nature, but just to get you to follow the order.
And so we're talking about consequences in enforcement proceedings and what can happen to you if you violate your court order. And at the civil contempt, we're talking about civil contempt. So I had a client, and it was over in Dallas, and he was just so angry with his wife about the divorce. And they had multiple properties, like several houses. They had the main house, and the wife wanted the big house sold. He was living in the big house. He refused to cooperate with the realtor and sign the listing agreement. And so, of course, the other side, and we had lots of conversations about, gotta do this, and he just was indignant. He would not do it. So we show up to court, because they had filed an enforcement, and the judge tells him, you need to sign this listing agreement, and he says, I'm not signing it. I refuse. This is my home. I want it, etc. And so judge says, okay, well, I'm holding you in civil contempt. Bailiff, arrest this man. And the bailiff comes and starts, putting him in handcuffs, and he's looking at me, and I'm like, I've been telling you.
Should have listened.
I've been telling you that this could happen to you. And so
don't act surprised now.
Exactly. So they take him back, they put him in holding, or they put him, towards the back of the courtroom. And I sit down and I talk to him, and I'm like, I know that this is really difficult, and I know you do not want to do this, but you have to. And of course, they had the listing agreement there printed, and he signed it, and they released the handcuffs, and that was the extent of it. But that's a good example of civil contempt.
So you didn't make the argument that he was physically incapable of complying because he was in handcuffs and therefore couldn't sign while
Judge
restrained?
ordered that he be released, his right hand be released from the cuffs.
Not his left hand.
Not his left hand. and he was still tied to something.
Good thing he was right-handed.
And so, but he signed it and he didn't go to jail that day. Suspended commitment is really what we see most
So
of.
before we go to suspended commitment, I want to talk about another difference between criminal and civil.
Okay.
If we can do that for a second, because I think it's important, the burden, right, the difference in burden, and why we don't use civil contempt a lot, but it's easier to prove, right? The burden is a lot lower, because in criminal contempt, obviously we're seeking punitive jail time, right? And so it follows a lot of the code of criminal procedure, right? I mean, you have the right to a court-appointed attorney. The burden is beyond a reasonable doubt. All the due process rights and stuff that a criminal defendant would have, a respondent in a enforcement seeking criminal contempt has, right? Whereas in civil contempt, you don't have that right to an attorney, right? You don't. The burden's preponderance of the evidence rather than beyond a reasonable doubt. So a much lower burden because it's not punitive in nature.
Right.
Right. And so I guess civil contempt would be easier to prove, but when you're doing criminal contempt, it's just got to be really specific so that you don't screw with somebody's constitutional rights. Because the judge will throw them out quick if there's something like that.
Right. And when we get to process, we can kind of line that out because we've been very successful in getting enforcements kicked out because of that very issue.
Probably because we learned from our own mistakes.
Right?
Would you say the Jimenez Law Firm is better than most at this part of your story, or average, or is that
Just
kind of
better
table
than
stakes
most.
as
Period.
far as this part?
Period. That's it.
You could have stopped there.
Yes, that's the answer. So I think that Floyd and I, we deep dive into the nuances of the law.
Sometimes to a fault.
Yeah, but because the consequences, the stakes are so high, right? I mean, somebody can go to jail for up to 6 months, and so we have spent countless hours researching and looking at cases, trying to figure out, okay, well, there's this one little word that was missing. Is this going to be enough to get this person off the hook? So,
and that's something I think that most firms don't really focus enough on, right? Is the strategy of it, right? Is how can I get them out of this, right? Just because there's an enforcement filed against you doesn't mean you're screwed. I mean, that old saying, where there's a will, there's a way, right? And sometimes we're grasping at straws to try to make it happen, and our arguments.
I think I taught you that where there's a will, there's a way, because you're normally.
I don't doubt that you would try to take credit for that. It's pretty common around here. So anyways, we try to find a way, right? And it requires, like you said, deep diving, researching, any little nuance,
So going to suspended commitment, what is that?
So it's the equivalent of probation, right, in a criminal case. And today, guys, we're talking about enforcements. We're talking about the suspended commitment portion of it now. We've gone over the understanding your order and the consequences of it. And suspended commitment is one of the consequences, usually used in conjunction with like a criminal contempt, right? So suspended commitment is like a probation, for lack of a better word. I mean, so you're sentenced to jail for whatever length of time the judge sentenced you to jail for, and then placed on suspended commitment. And so instead of going to jail, you're going to be supervised, right, and have to comply with certain conditions. If you violate those conditions, then you go to jail, right?
Everybody always freaks out, though, when I tell them suspended commitments like probation. They think, oh, I'm going to have to report. I'm going to have to go to a probation officer, and I'm going to have to do a drug test. And no. It's not like that. It's not like in a criminal proceeding, right? So typically you have to comply with all provisions of the order, right? You have to pay your child support on time. You have to return the child on time. There's lots of different things that the court can specify within your order. Pay attorney's fees on time, pay your child support on time, but it's only going to be related to that order.
Well, now they can order reporting.
They can.
Yeah, and I've really only seen that a lot in Dallas.
I don't know that I've ever seen it in any of my cases.
I've had a couple of my clients, unfortunately, that had to do reporting probation through the AG's office. I've never seen it on a private attorney when the private attorney was on the other side, but through the Office of the Attorney General in Dallas, a couple of times my clients have had to do reporting probation or suspended commitment.
And then the last thing is attorney's fees. And so that's a big one, because if you are held in contempt of court, and it doesn't matter if it's civil contempt, criminal contempt, or if you're placed on suspended commitment, the code says shall, right? And so that means that the court, it is a shall, right?
So I was actually going to ask you that, because I always get this confused, but I think it's a shall if they're so far behind, or shall if. I think at some point it's optional. No?
Remember. I feel like it is mandatory if you're held in contempt of court. We'd have to look that up clearly.
We'll do our deep dive.
Our deep dive, and we'll come back to that. But attorney's fees are something that you will receive if, or you should receive, if the other side is held in contempt of court.
And the reason that we haven't deep dived into that is because they're ordered, right?
Yep.
But I do think that there's a nuance in it that says if it's below this, it's a may, and above this, it's a shall. But they're always ordered. Like
Yeah.
if you go under enforcement, they're always ordered.
So, how to file an enforcement, like how does all that stuff shake out whenever you actually need to move forward with an enforcement proceeding? So let's say, hypothetically speaking, you go to your attorney and you say, I want to put this person in jail because he's not paying child support, right? I want to put mom in jail because she's not allowing me to see my kiddo. So typically, one of the first things that we're going to do is we're going to look at your previous order, right? And how many times...
Well, I would say not typically. We're going to know whether there's been a violation.
We're going to look at the order.
Because
we have to.
We can't guess. That's part of understanding your order, which we talked about earlier in the video, right? We have to understand your order too, right?
Yeah.
So,
Yeah. So we are always going to look at that order first. But how many times have you been, I don't know, I guess disappointed, for lack of a better term? Like, so when we're not the previous attorneys, right, and they come to us from another attorney, and we go and we read that order, and the language is not enforceable. It
sucks.
It sucks so bad. Because...
That happened to me with Taylor.
What do you mean?
Well, the geographic restriction information had no consequences when my ex-wife moved to Pennsylvania.
That's a
it's
different...
while back.
That was a different issue, though.
I got you.
So yeah, I mean, it's just one of those things, and it's silly things, right, that I think some younger attorneys miss, or maybe attorneys that don't practice family law quite often miss. It's like the surrender language, right? Like so whenever you have possession and access, there's specific language that says you have to surrender the child at a certain time, at a certain location, and a lot of times attorneys don't put that language in there. And so she may not be showing up every Friday at 6 o'clock, but because that language isn't in there, you're stuck.
So I ruined that take with my thing on Taylor. Can you start over? Because this is good. You've got a lot of energy. So
What are we talking
just
about?
go back 2 minutes to previous lawyers when you get new. So
Yep.
sorry.
You're good.
I want this, and I don't want to remember.
That's a really good part.
Okay. So, talking about the process, right? When clients come in and they say, hey, I'm not able to see my kiddo, hypothetically, mom's not bringing the child over to visit me on Fridays at 6 o'clock when the kiddo's supposed to be there. I can't tell you the number of times that I've been just like so disappointed and just frustrated, and having to sit there and tell the client, like, listen, I've looked at your order and it's not enforceable. The language isn't there that needed to be there. And so...
Yeah, it really sucks for them, right? Because they've been wronged. They come to you for a remedy, and they deserve a remedy, right? But you can't do it because somebody else did, and it's just...
Yeah.
Sucks.
Your language in your order has to be very, very specific, right? And there's certain language, there's too much to even explain on a podcast, but there's certain language that has to be incorporated in order for certain provisions to be enforceable. And if it's not in there, we can't help you at that particular point. And I say that. I mean, we can file a motion for enforcement. We can request clarification of the previous order to make it enforceable. So that is a remedy for future violations, right? But the judge literally cannot put them in jail if the language in the order is not enforceable.
And again, the reason for that, I mean, particularly when we're talking about criminal contempt, right, is always related to an indictment in a criminal case, right? The respondent, in this case, and defendant in criminal cases, right, they have a right to notice of what they're being charged with and what the allegations are, right? And so without that clear, concise language and the specific order language and all that, they're not on notice, not at least not sufficient notice to be held in criminal contempt and put in jail for it.
Right.
So, yeah.
And that's one thing that I see sometimes, like let's say the other attorney drafts it, right? And they send it over to us for approval. Sometimes I see that, little things are kind of missing that would maybe make this order enforceable, that would be beneficial to my client. And so I'm going in and I'm correcting the order to say, like, hey, we need this shall, we need the it is ordered language in there, we need the address of the location in there. And so those are the things as attorneys that we should be looking for to make sure that our clients have remedies.
And of course, we only fix those if it's the other party that's ordered.
That's the
we leave it
truth.
very vague when it's our client that's ordered.
That's not true.
We want to give them that out.
And so first thing on the process, like how do we file, right? So we're going to look at your previous order. We're going to make sure that it's enforceable. And then from
Typically.
there, always,
Okay.
we're going to do that. And then what do we do?
Then we file an enforcement. We draft a motion for enforcement, is what the pleading is called, of whatever it is. And we put the language in, we get the violations together. There's specific ways the violations have to be spelled out depending on what the violation's for. Right? I mean, child support, you have to have the amount due, the date it was due, the amount paid, the date anything was paid. Possession and access, time, date, location of exchange. So it has to be very specific again, notice stuff. And so get all the violations in the order, get it filed, and then we get the judge to sign an order to appear.
So let's say, hypothetically, enforcements are filed against our clients, right? And
Our clients don't do anything wrong.
right, never. They're always
So.
wonderful. But if the other side files an enforcement against
Wrongfully.
them, then what we're going to do is we're going to review that motion. And, on the flip side, that's, I guess, kind of a potentially happy moment is whenever I'm looking at somebody else's enforcement, another attorney's enforcement that they've drafted against my client, and I realize they've screwed this up, right?
That's kind of fun.
Yeah, it's like, ooh. And it's almost like, oh man, I wish I could tell them that they don't know how to do this, but I can't. And so when that happens, we just kind of sit on it and we wait for the hearing. Because then what happens is you go to a hearing. So like Floyd said, there's an order to appear. We all have to show up, because if we don't show up, then
Then you get to go to jail
a warrant's issued for your arrest.
because that's a violation of another order.
Right. And so they'll go and they'll issue a warrant, and then they'll pick you up, and then they'll bring you back to the courtroom so that you can answer on the original violations. And so when we show up to that hearing, we allow the other attorney to call that first witness, and after they call that and ask one question, then at that point we ask that it be dismissed because it's not properly pled.
Yeah, and so that doesn't happen a lot with the attorneys on the other side, right? But I had a pro se party not long ago that filed an enforcement against our client, and pro se without an attorney, right? And these things are difficult for attorneys to draft because they're so technical. And she clearly didn't know what she was doing, right? But we go to court, I use the same strategy, right? I mean, I let her call my client after a couple questions, lodge my objection, and requested that it be dismissed with prejudice, right? And the judge felt bad because she knew what had just happened. And so she had to get off stand, and she was telling her, like, look, I'm not going to dismiss it with prejudice, but I'll dismiss it and give you the right to refile. And so then I told Judge, I believe jeopardy is attached, right? And so at this point, she can't bring it back because the double jeopardy, like I say, criminal stuff, right? And then judge felt really bad. And judge was like, I'm sorry, I have to dismiss it with prejudice. You can't refile. And so what that means is all those violations are now gone. She can never bring them up again because of a procedural issue, right? And it's the same thing when you hire an attorney does that and messes up the pleadings. Good for us, but we don't want to be the attorneys that do that for our clients, right?
I had a case where our client had shown up to the first proceeding pro se, and apparently she did not have a very kind attitude towards the judge, and judge got pretty upset with her, and judge reset that hearing because it was an enforcement to allow her time to hire counsel. And so of course I talked to the other attorney, and I'm looking at her pleadings, and I find out very quickly that her pleadings are improper and it's not going to go well for her. Of course I can't tell her. And the other attorney's like, this judge is ready to put your client in jail because your client was downright nasty to this particular judge at this last hearing. And so we show up to the hearing, do the thing, let her call the first witness, and after that I say, Judge, it's not properly pled, dismissed with prejudice. And this judge's face, like she was so angry that she had to do it. And in that particular motion, that the other attorney had only filed for up to a certain date, and so the judge says any other violations that have occurred after this date, you can still refile, but your case is dismissed with prejudice. And they never did file, thankfully. But with enforcements, it's all about the technicalities. That's the way that you have to proceed with them. That's the way that you have to defend against them. If there's no way to get out of them, right, then we have to figure out a way to negotiate and bargain, because sometimes there's just no way to get out of it. You made a mistake, or the other side made a mistake, so let's work it out the best way that we possibly can.
And that's, I think, where we excel, right? I usually have great ideas on how we can strategically gain leverage against the other party to use that to get the other people to drop their enforcement.
Just Floyd has those great ideas. Oh,
that's the first thing today you said, correct. That's amazing.
And so with that, thank you so much for joining us on the consultation. I hope that this was informative. I hope that it was helpful. Make sure that you follow us on all social media platforms. That includes YouTube, TikTok, Instagram, LinkedIn, etc. Have a great day.
Don't violate your orders.
Don't violate your order.